we all know that, ethical challenges are prevalent in elderly because of the vulnerability, not just in terms of physical, but social, and here we have an added layer of cognitive vulnerability, where we are talking a person who has a problem with thinking, and hence a lot of times is cast aside in the family and is not able to advocate for his own rights. And here we're talking about how we want to look at respecting rights of these people. Again, here, the underlying question is, we must then say that I think that our professional ethos is that we should try to respect these patients, and this is the basis of where I'm going to start from. And one of the most challenging thing about dementia is that at different stages, the extent of functional decline, the severity of the symptoms, challenging behavioral symptoms, the extent of impairments in decision-making capacity varies. And so, it's like a goalpost. The size is just changing all the time, and where you have to then change your approach, change your goals, and change the plans that you have made for the patient. And it's not just one standard approach. I'm going to just talk about decision-making, genetic testing, driving, and living alone. I probably won't have time to talk about truthful disclosure of diagnosis and restraints. It's in the guidelines. But the ethical principles for these are probably quite similar to that for any elderly patients. For decision-making in patients with dementia, I think our basic premise is that, first of all, the right of self-determination of these patients should be respected to the extent possible. It is, as I said, it will change, and most of the time it will decline relentlessly as the patient declines. And there is some point in time where the patient's own decision is going to be harmful to the patient. And that is when our orientation changes from one that we want to protect the patient. But I think it's important to remember that the diagnosis of dementia per se does not automatically mean a loss of decision-making capacity. Many a times we find the junior staff or even senior staff when a new patient arrives in the ward, and when they look into the old notes, nowadays the previous history is all printed in this thick stack of computer-generated data. And the moment they see the word dementia, suddenly you'll find the approach is very different. They stop talking to the patient, or and they probably put a DNR on the case sheet, and they assume that this patient is not able to make decision, and even in terms of what they want to eat and all that is all decided for the patient. But I hope that we can come away knowing that there are varying stages, and in the early stage, patients are very well able to make their own decisions about some very basic things, and really we need to match the task to their cognitive abilities at that time. When we talk about assessing the decision-making capacity, we are really talking about the ability with respect to a particular decision. The ability of a person to decide whether or not he would like to wear a red shirt today is quite different from the abilities required of him to decide whether he wants, how he wants to divide his entire empire of houses and stocks and all that. It's just very different, and we cannot assume that just because he can't do something that's more difficult, he also cannot decide what he wants to eat today, whether he wants to go through a very simple procedure to remove a lump. So we are looking at essentially the model of 4 functional abilities: the ability for them to express a choice at the end, a consistent choice hopefully, ability to understand information provided, ability to appreciate the significance and relevance to self, and ability to manipulate information rationally. You realize that it is an escalating level of demand of their cognitive abilities. So we generally apply this sliding rule approach, where if the consequences of this decision, whether they agree or disagree, is significant, has a significant impact on their health or their social condition, then we require them then to express a higher level of ability to explain why they refuse something that's beneficial. A lot of times in awards we find the practice that if the patient agrees with you, they have ability. If they disagree with the doctor, then they lack the decision-making capacity. I hope we can move away from that model, because a lot of times patients can agree with you for the wrong reason. For example, a patient who agrees with an amputation may think that the new leg would grow out the week after, and then you really got to re-examine the ability to agree and whether that's really a valid consent. I think it's important that it does take time to assess all this, but you'll find that a lot of times this is the process that you need to go through. A lot of dementia patients have problem with memory. They cannot remember the facts. But you present to them the same facts. They usually make a consistent decision based on consistent sort of steps of logical deduction. And legally that, I've been told, is a valid sort of decision or consent, because given the same facts, they arrive at the same conclusion using the same process, which is very logical as you examine it. Now, what if the patient lacks adequate decision-making capacity? What do we do? I think the problem we find a lot of times, perhaps it does happen at primary care practice, but certainly in the tertiary care practice, the problem of sometimes under-treating them, as I've said, to dismiss them and not even give them treatment that are very important in improving their comfort and symptoms. There is also the problem of over-treatment, this spinal or maybe sacral response of, the textbook teaches us for this condition we must do this, and everything is ordered for the patient without regard for the patient's functional status and stage of dementia. So you find a lot of very patients with advanced dementia in the ward being subjected to very aggressive treatment, which at the end does not change the outcome. So I think for these patients, there's certainly the pitfall over and under and over treatment that we need to guard against. Well, for very specific conditions that patient who is, fits the Advanced Medical Directive Act, where you are terminally ill, death is impending, you need extraordinary care. If the patient has made an advance directive as per the AMD Act, then there is certainly a power of legal enforcement that we should look at and we should enforce. We must enforce it. In fact, the Act says they should, means we must. But this is a very specific and narrow sort of scenario. A lot of times it's outside of the AMD Act. Now, if a patient has made some explicit advance directive telling you, I don't want an amputation, should I, become unconscious? Because what happens a lot of times, they say, I don't want an amputation, and when they become unconscious, they wake up without their legs. No doubt it's for their medical good, but I think the patient has expressed a choice when they have the decision-making capacity to say no. So this sort of explicit advance directive, if it is unambiguous, if it's clear, they should be respected to the extent possible by law and by our professional ethics. Certainly our legal framework does not have this provision to enforce it legally. It can be challenged sometimes by family who want patient to survive and so forth, but I think we have to look at what our profession says about respecting the patient's wishes. Now, in the absence of any explicit and unambiguous advance directive, the patient's dignity is respected by decisions that are aimed at achieving the patient's best interests, and we shall go into that a little bit while, and that serves to protect the patient from their own harmful decisions or actions. In immediate life-threatening emergencies, I think that's clear-cut. If a patient is brought in hypotensive, collapsed, unconscious, it is treated by doctors based on the principle of medical necessity. I think very few would challenge that, unless he has made very clear pronouncement, maybe set up a blog that says he doesn't want this if he's found collapsed on the road and brought to the ED. But in less emergent situations, the common law that we inherit from the English law says that we've got to treat the patients by best interest. If the patient has a legal guardian, the determinant of what's in the patient's best interest would go to the legal guardian under the Mental Disorders Treatment Act. This, you've got to go to High Court and apply to be appointed as a committee of person. In the absence of any legally appointed guardian, then generally it's the doctor who assumes the role and make the decision based on medical best interest, but in consultation with the relevant and appropriate next of kin. You've got to take into account patient's values and all. So you've got to talk to the family, the people who are close to him. Justice Chuantek has affirmed in a case last year in the High Court that opinions of the patient's next of kin ought to be sought, but they are not legally binding. You do not, the patient's family do not have the final say as to whether the patient should receive an amputation or not. You have to base it on the medical facts and also what the patient's values are. So I think making a decision for people who are unconscious, it's always a difficult decision, Going to a restaurant, trying to order food for somebody who's not there, not knowing whether he likes spicy food or not, is always a struggle. And you wish he had already made a call and say, I don't want this and that. But I think for patients like these, we have to strive. We have to try to make decisions that are logical and yet respecting of their abilities while there still are these residual abilities. Genetic testing on dementia has to rely on two things. One, does it benefit the patient? Secondly, how would that modify patient care? So, and especially in pre-symptomatic susceptibility testing, individuals must be clearly informed because there are potentially detrimental effects on them psychologically, especially if there is no treatment and there are devastating effects. What happens is that you may destroy his life even in the pre-symptomatic stage. And this is sort of anticipated grief and so forth can paralyze a person and destroy the number of good years he could have lived before the disease surfaces. And then there are ramifications on employment, medical insurance, because if they are asked, if they ever had a test, they are expected to tell the truth, I presume. And then there are implications on a positive test on genetically related family members who may not have wanted the test, who may not have taken the test themselves and so forth. And that itself, the unique thing about genetic testing is that you may be testing one person, but a lot of times there are people related and they could infer their status on the results of this person. So confidentiality and all that is very important, and how you would counsel the patient and whether they would share that information with their relatives. Well, fortunately, I think at the moment at least, there are no established genetic testing that are meant for clinical use. The ApoE genotyping that we have heard a lot about, yes, certainly there is a strong body of evidence to say that it's an important risk factor associated with AD, but at this moment at least, there isn't sufficient sensitivity or specificity for it to be used alone as a diagnostic test for AD, and it's not recommended presently for routine use, partly because also we don't have a cure for the disease. And secondly, it is also not established as a predictive marker for AD. You may be tested positive at the age of 20. It doesn't mean that for sure you will get the disease later on, and certainly the utility is not good enough, and does not provide any medically useful information that if you belong to this. The people have tried to link it to whether they respond to certain treatment. At the moment, the data is still not strong. So susceptibility testing in an asymptomatic individual is not recommended and may be associated with potential psychological harm. That does relieve us clinicians at the moment from this struggle of whether or not to do genetic testing, but I think maybe in 5 to 10 years' time, or maybe even faster, this is going to come up from the horizon. Driving is, as we all know, it's a complex task. First of all, you've got to recall the traffic rules, and then you've got to apply it carefully. And then you must have sound judgment because the situation changes, and then attention span, quick responses. It's like a computer game that is quite challenging, except the consequences can be quite drastic if you make a mistake. And it has been shown that drivers with dementia are associated with increased risk of accidents, not surprisingly. Yet, at the same time, perhaps even more so even in large countries where people are more dispersed, and you need the vehicle to bring you from one place to another to survive or to reach your pleasures in life. Driving represents, it's seen as a symbol of independence, freedom, mobility. So the issue of driving dementia requires thus the balancing of individual freedom and patient confidentiality on one end versus patient and public safety. It's always a struggle, it's a challenge, and after all these years of managing some patients, and thank God many of our patients, elderly patients, don't drive, but trust me, in 5 to 10 years' time, we're going to see this problem more prevalent. It's always a struggle. What do the data show?